And we're on. Hello, Anish.
Hello, how are you,
I'm
Michelle?
well. Thanks.
We're here. We're here for another episode of the Achad and Coco Report, and today we'll get right into it. We're going to talk about the Alfie Evans case. Much to say, partly because we're recording this in the afternoon, and poor Alfie Evans passed away early this morning at around 2 a.m. Just to briefly summarize the case, Alfie was a child that was born normal in Liverpool, in England, and at around early on, I don't know exactly what month, started showing signs of some neurologic decline and went to the hospital. And essentially, because he had such rapid neurologic decline, wasn't even able to breathe on his own and was ultimately put on a ventilator. And the report is that he's been in a coma on a ventilator for many, many months. There was a disagreement between the physicians that were taking care of Alfie and the parents in terms of what the next steps should be. Alfie's parents were looking for other treatment, perhaps even, they found a doctors in Italy who were willing to take care of the child and continue treatment, continue life support. Alfie's British physicians at the Liverpool hospital they were at disagreed, and finally this ended up in the courts. The courts ruled in favor of the physicians, and the parents were not allowed to take Alfie out of the hospital, let alone to any other hospital. They took him off life support, again, I believe against the parents' wishes, and approximately 3 days later, Alfie passed away. So sad case, but what do you think about all this, Michelle?
No, you're right. I mean, I think it's outrageous, but at the same time, I really want to be dispassionate about it because obviously, a lot of thoughtful people, including the courts in England, have sided against the parents and in favor of discontinuing the care. And this is not the first time. It's very reminiscent of a case that took place a year ago or so with a baby named Charlie Gard. I don't know if you're familiar with that case.
Yep. No, absolutely.
Very similar. Charlie Gard had a diagnosis that was known to be terminal or without any treatment, except that there was an experimental treatment, and a U.S. physician was willing to give it a shot, take care of the baby. The family had raised money privately to transfer the baby, and the courts, the medical system, the doctors refused, and the court sided with the doctors. And this is similar here. The only difference is that the diagnosis is mysterious. It's unknown. But likewise, it wasn't going to be at the cost of the taxpayers or the state. So what I think is remarkable here is that in both cases, what is invoked by the physicians and what is invoked by the court is the doctrine of, is the child's best interest. And that's really specifically why they refuse to abide by the parents' wishes. And they say, no, it's in the child's best interest that he should die. And that's really quite, I can't really, it's not new. It's been around in medical ethics for quite a while.
Yeah.
But it's really remarkable that now reasonable people can say that it's in the best interest of someone to not exist, to essentially not have interests anymore, because when you die, you don't have any interests anymore.
Right.
And that's so I read just this morning, there are many documents available online with this Alfie case, and I read the judgment issued in February by the court, by one of the justices of the court, and he goes through the case in meticulous detail. There's no disagreement as to the facts of the case. There's no disagreement that the child has a terrible condition, that he's progressing, that they're, in all likelihood, he was going to die, and so forth. No disagreement. Even the parents have no disagreement about that. And they fully recognize that in all likelihood, the kid will not, was not going to make it. But they disputed the question, and it's in the document. They disputed this notion that it's in the child's best interest to be taken off the ventilator and to be allowed to die essentially by by not breathing and so forth. And so when I looked at the document, the judge refers to a document issued by the Royal College of Pediatricians that was published in 2015, so recently, and it's really essentially guidelines about when is it okay to withdraw care for kids. Okay, and so I have it. Let's see, where do I have it? I made a copy of it, but essentially the document outlines. Yeah, here it is. It says, there are three sets of circumstances when treatment limitations can be considered because it is no longer in the child's best interest to continue. And of those three, two don't apply here, and there's one that applies. So the first category is when life is limited in quantity. And that's essentially when the kid is dying, in the process of dying, because, it's inevitable death, which is not the case here. And I'll come back to that, I think, maybe later. But here it's clear that at least he was, his vegetative functions, to some extent, I mean, he was not, supposedly he was not breathing on his own. That's what was claimed. But obviously, when they took off the ventilator, he survived for 3 days. So he was able to breathe on his own for several days. So against predictions, he was actually able to breathe on his own. He was also digesting food. So he was being fed by an NG tube, and he was growing. So his vegetative functions were, more or less there. And so it was not a question of imminent death or he was vegetatively surviving. So and that's not, the judge does not invoke limited quantity to make his argument. The third category is
so the baby did, Michel, did pass away.
Yeah, but he was not fed and not he was dehydrated, So I'm not sure the circumstance, but he was kept without food or
no. Yeah, I mean, there was, I believe he was fed. Initially he was not fed, and I mean there's some reports by the father saying that there was some time. So eventually he was fed. He was being given IV fluids the whole time, even after the ventilator.
Okay, you're right. I stand corrected on that. But
right. So
nevertheless,
so I mean the baby. I mean, if from a quantity standpoint, it sounds like the baby did need ventilatory support, and ultimately passed because he wasn't able to be continued.
Correct. But I think the way in the Royal College of Pediatricians document frames this category of limited in quantity, they say, where death is not, is inevitable, is not immediately imminent, but will follow. I mean, I don't think there's any clear indication here that he would not have lived another few weeks.
If what? If he didn't have the vent?
No, if he was kept on the vent.
He was kept on the vent, yeah. If he was kept on the vent, it sounds like he would have been.
Like he was growing, he was digesting food.
Yes, right.
I mean, he was clearly having seizures, but he was, in that sense, the treatment was prolonging his life.
Right. Prolonging his life.
So that wasn't invoked by the judge when he made this decision. Okay. The third sort of category is informed, competent refusal of treatment, which is again not invoked here because the surrogates, who are the parents, were not asking for withdrawal of, I mean, they were not right. making. So really, the category, the judge cites this document and he says, when life is limited in quality, okay, and so he and all the doctors, or the doctors who were in favor of withdrawing the care, were making a judgment that the quality was such that it was in the best interest of the child that he be dead. And what's even more remarkable is that in that document by the Royal College of Pediatricians, they say that even, let me find that passage here, even if the child is not suffering, even if there's no evidence of pain, here, let me read it here. Even in the absence of demonstrable pain or suffering, continuation of life-sustaining treatment may not be in the best interest of the child because it cannot provide an overall benefit to them. What does that mean? That really makes no sense whatsoever. it's a to me it's a Freudian projection. It's the doctors that are suffering for some reason, I mean, I don't know, imagine that, and they really want to stop their own suffering, and they want the child to die so that they can't move on. But it makes no sense whatsoever to say that it's in the best interest of the child, even if he's not suffering, right? Even if the baby, he or she, is not suffering,
right?
Because life-sustaining treatment does not provide overall benefit to them. It's not new. It's been going on, in various cases. It's variations of that doctrine has been invoked in other cases, and the Terry Chavo, to some extent, case and other things. But here, I mean, I think it's really bizarre, and that's why it's. But for some reason, people, including doctors, including thoughtful and well-meaning people, because there's no question that the doctors who were involved were well-meaning. They went through all the tests that they could. I mean, they were very thoughtful about it. It's well documented, and the parents are not in disagreement with that.
Yeah.
But somehow they believe, they make a judgment which is completely subjective, and then it allows the state, to control the baby against the wishes of the parents, even if the parents have the means to take, So it's not a matter of rationing care, which is crazy, because I think there is an argument to be made, on the basis of rationing, right? If they had said, it's too expensive, we have to be thoughtful about the community, I think that actually, to me, it makes sense. It's still problematic in a single payer system. It's kind of problematic because, how do you come up, what criteria do you use to make the arguments from rationing? So it's problematic. But on the other hand, it's more sensible. But that's not the argument that is being made. Now, when it's discussed, and that's why I want to bring up these points, because when you hear discussions or people, being pro or against, all these arguments, some people think that the baby was suffering. There's really no evidence that we don't know that he was suffering or not. I mean, he was seizing at some point, or he is seizing under certain circumstances. But in other cases, at other times, the document says, we think he is fully unaware, he's completely in a coma. So we have no idea. We really have no idea what it is to be this child. So we cannot assume that he is suffering to such an extent that, it's in his best interest not to suffer anymore by dying. Right. So that's what I find remarkable about this. Yeah. And then people say, well, it's a rationing thing. Well, if it's a rationing thing, let's frame it in those terms, in those terms. Yeah. But that's not a rationing. It's not. Right. It's not. It's very bizarre. It's very bizarre, and it's the status of modern medical ethics, and it's highly disturbing to me.
I mean, you understand. Yeah, I mean, you understand where all of this arises from. I guess this idea that, and this is not just in the UK. This is that the state can intervene and supersede the rights of the parents when the rights of the child are being when if the child is a danger. Sorry, if the child is in imminent danger of harm, or the child is suffering. Right. And there have been some, this idea that the parents always have the final say over kids, which has some precedent. And there's some social contract for that over the centuries. That unfortunately, there are these unique, cases where you have parents that harm children, that abuse children, that put them in dangerous situations, and the state the state needs the ability, or I think would you agree that the state needs the ability to intervene on the behalf of children in those cases?
Yes, yeah. I haven't thought through that, but I think you're correct. I mean, I think there is. Certainly, I mean, let's grant it. Let me grant to the state the ability to intervene here if a child is being abused. The difficulty here is that frequently the solutions are not that great. But let's say that they were. I mean, I'm willing to grant that. But that's not what's invoked here. I mean, the judge clearly says he recognizes that the parents are really loving, that the parents really want what's in the best interest of the child.
Right. But what if, again, there's this idea that the parents may be so emotionally stricken, and there may be so much emotion in it that they're not thinking in the right sense, and so therefore they, even though they want to have Alfie's interests at heart, they really can't make that decision because they're too close to it. So the thing is, Michel, we don't know. None of us know if the child was suffering or not.
Correct.
I mean, look, for me, look, I mean, when I had my very when I had my challenges with my child, I mean, every day that the child was on the ventilator was a massive thing. Like, so I
No,
mean, so
I agree.
you can't imagine.
We'll put in the show notes the blog post that you wrote about your experience. I mean, it's not
Yeah.
completely related, but I think it's worth it. It's such a great piece that you wrote. I think we'll put it in the show notes if people are interested.
Yeah, but here the child has been on a ventilator for 8 months, right? I mean, so I can see how the physicians and the care team that are taking care on a daily basis may feel that this is putting a child through a place that is a child through things that are that aren't reasonable. So I mean,
Well, I don't know. So I agree. It's not a malicious intent on the part of the doctors.
Right.
But I dispute the question that simply on the basis of suffering that's enough to terminate the life, because I mean, even if you, I mean, how do you, first of all, if you're a materialist, and you think that there's no life after death, I mean, let's assume that's the case.
Right.
You still can't argue that it's better not to be alive than to be alive. Right? I mean, how can you argue that it's better not to be alive than to be alive, even if you're a materialist? I mean, at some point, if you're a materialist, I mean, you have to concede that it's better to be alive than to be completely non-existent. Right? I mean, to be right. So, I mean, or how can you make that judgment for somebody? But I want to go back to the question of the child, because I wrote a blog post on assisted suicide, and I used that argument that so in this case, when the body of the child is assimilating food and growing, right? So to me, I use that as a body language. So I use that as a sign that human being, which is really one human being. I mean, it's not a mind and a body separate, right? It's not a mind. It's a body that is continuing to grow. So to some extent, that body continues to demonstrate a will to live. I mean, not necessarily a conscious desire, but there's some organized activity that is that continues to want to assimilate food, and is growing. And since I don't know anything about suffering, and I'm not even sure that suffering would necessarily trump, would be a trumping argument, I'd say that if they want to continue to support, and they have the means to do it, they're not burdening society because they're doing this with private means, or there's another community that is willing to shoulder the costs. Then I really think that they should be allowed. And it's really, to me, kind of chilling to make the claims that we know what's in that the best interest is to be dead, right? I mean, to me, that's a very, very chilling claim.
Right. Well, Michel, let me start by saying that I also vehemently oppose this idea that the state can supersede my rights.
All the doctors. I mean, it's if the doctors, because it's right. Go ahead.
Right, and this argument that's made, I sent out a tweet saying, "Hey, can some British doctors comment?" And like, literally, someone said something about the fact that no, it's not the state intervening; it's the courts. It's like, what are you talking about? This is like, who are the courts? I think you're the one that said, are there private courts?
Right.
Clearly, that's a cop out. But
I see it. Right. Go ahead.
So I'm with so I can't imagine that like if my child is in the hospital, like it's my child. It is. I mean, who are you to suddenly not allow me to take my child out of the hospital? To me, it should strike me and should strike everyone as just utterly ludicrous, unless there's some thought that you're going to take the child and start abusing the child. In this case, they were trying to, they're holding on to hope that somebody could do something for their child, right? And here, they did not allow the child to leave the hospital with the parents because the parents were deemed a flight risk. Because
that's right. That's right, and it was
unbelievable.
The judge's decision. Comment at some point. He says, we wouldn't want the child to die on an airplane.
Yeah, and they literally made up stuff about the fact. Well, I mean, you know what? I'm probably being too flippant about this, but they said that they can't put the child on an airplane because that stimulation may cause more seizures.
Right.
I mean, where is the evidence for that? That is just wild hand waving.
Correct. It is wild hand waving.
But I think it raises. So in this case, there are some things that are egregious that really are very upsetting to me. But let me ask you about what Catholic teaching is. Not being Catholic, you would know better about this, but Catholic teaching in terms of end of life, because
Right.
there are some nuances there, right? Like in this particular case, or the question is, even speaking generally, that it's if you're using extraordinary means to continue to support life, and extraordinary in our world today of impellas and ECMO and stuff is certainly that is relative in terms of what extraordinary is now versus what extraordinary is 40 years ago. But I don't think it's unreasonable to say that, look, mechanical ventilatory support to prolong life indefinitely until you have some other thing happen, that's the thing that I think there's some point to the idea that, yes, you don't want to end life, you don't want to hasten death, but you necessarily want to prolong life by continuing mechanical ventilatory support. So
no, you're correct. So ventilator support would be considered, or could be considered, extraordinary means.
Right.
Let me preface here. People may not know, but Alfie's parents were Catholic.
Yes, they were Catholic.
So they're Catholic.
And Liverpool has a high percentage of Catholic folks as well. The hospital.
I suppose so. So they're Catholic.
Yeah.
The opinion of the judge, or I read somewhere that they were, maybe not, it doesn't matter. They were not practicing Catholics. It doesn't matter. But then the Vatican, the hospital in Italy was actually the Vatican's hospital that they accepted. So there's this teaching. There's a long tradition about when is it okay. So there's a presumption that you want to, in general, you want to sustain life. Okay, there's a presumption in Catholic teaching that you want to sustain life, but it's not at any cost. And so there's been a doctrine that's been elaborated over the centuries, starting, even back in the Middle Ages, about when is it okay to refuse care.
Right.
And it's actually always been accepted that it's okay to refuse care if the means to sustain life seem to be extraordinary and of undue burden. And the undue burden can be physical, if the pain is going to be too much, psychological, if the suffering is going to be too much, or financial, if economically it's going to, ruin yourself or your family. So you're not expected to sustain life at all costs. And withdrawal of extraordinary means is always acceptable. Now, nowadays, applying this doctrine of extraordinary means today in a modern society with a welfare state is kind of problematic to me, and it's not clear in the official documents of the Catholic Church, because when is a financial? That's why I think rationing, or financial considerations are important and are valid. But when you have a third-party system and so forth, it confuses the issue, because then, who determines that the financial burden is too much and so forth. So you're right. I mean, there is a case to be made. And if the parents wanted to withdraw care, there'd be no problem from a moral standpoint, at least from a Catholic moral teaching standpoint. There'd be no problem. They would say that it's an undue burden. They may not specify, but they could say sort of economically it's an undue burden, to or whatnot, or too much suffering. But you have to make that case. So the parents would be the ones making the case, and it always has to be. It's a decision that is made, based on the specific circumstances. And I don't know that there's anything you cannot have the state making. Again, so sort of this problem with rationing and third parties being involved, and these the ventilator support being an extraordinary means is problematic and almost absurd when you have third party payment, because you cannot resolve that. It's absurd because it cannot be really judiciously resolved. But at any rate, I mean, the bottom line is that none of this was invoked here. I mean, it wasn't an issue here. What was at issue is the notion that the state can determine the best interest.
Right.
And they thought that it was the best interest of the kid to be dead.
It certainly gets
right. So the intention, that's the problem. The intention is for the child to be dead, right? It's not the intention that you withdraw extraordinary means. So in Catholic teachings, you'd withdraw extraordinary means, but not with the intention of the baby being dead. You'd withdraw the means precisely because they're burdensome, okay? And then you still hope for the kid to be alive.
Right.
So it's
Right.
really
But that
the opposite here. The intent is for the kid to be dead.
Do you think so though, Michelle? Because I
Yes.
think
Yes.
because I mean, did they not say that the intent? I mean, what they intend to say, look, we will no longer continue extraordinary support. We will no longer mechanically support the child. They withdrew the ventilator. They continued feeding after a brief delay. They continued IV fluid, and then the child passed away. 72 hours later. So
Right.
that seems to be in keeping with the wishes of, because the plan in terms of what was going to happen in Italy, for instance, in this Italian hospital, was that they were planning. They were willing to do a tracheostomy and willing to do a gastrostomy tube, a peg tube, feeding tube, and keep the child alive longer in that manner.
No, so I think you bring up an important point, but it's a crucial difference, and I think I'm pretty firm that it's distinct, because here the courts and the doctors wanted the child dead. They thought it's in the best interest of the baby to be dead.
Did they specifically state that, Michelle?
Yes, well, because
okay.
I mean it's sort of it's implicit in the doctrine of best interest that life sustains. Because let's say they had stopped the support, and did the child suffer any less while he was without the life sustaining treatment? No, I mean the conditions were the same, right? The conditions were the same. Right. So in essence, the only difference was that they anticipated death. And so I'm not sure that it's clear. I mean, I don't know that they would frame it in those terms, but it's the logical conclusion of this doctrine of that it's in the best interest of the child for life sustaining treatment to be withdrawn. I mean, that's really the logical conclusion. There cannot be any other conclusion, right? Especially the way it's this case has unfolded. So,
right. No,
so I think it's bad. I mean, I think it's important for doctors to reflect on these things, what we're talking about, and try to start to at least parse these different arguments, the arguments about rationing, the argument about extraordinary means, and the argument of best interest, this alleged argument of best interest, and what the intention is and all that. Because if you're not paying attention and you just read the papers or you're on social media, it's easy to get confused by all these things get sort of
right.
Jumbled up in the conversation.
There's some very, very interesting issues that are raised by this that none of them are open and shut. But it does seem that, as I said before, that the idea that the state can supersede you as a parent when what your wishes are the best thing for the child, and they can come in and say, no, we know what's best for the child. You do not know what's best for the child.
Right. Even though they
very hairy,
it's very, very chilling, very problematic.
Yeah. All right.
Okay, Anish. Anything more to add on this?
I think that's good. I think we've.
I put in the show notes. I put a link to your blog post, and I'll put a link to a couple of things that I've written on Charlie Gard, the other case we talked about. And all right. See you next time.
Take care. Yep. Thanks.
Bye.